Ms. Taylor, is Mr. Kohberger prepared to plead to these charges?
Your Honor, we will be standing aside.
Bryan Kohberger stood silent during his arraignment on burglary and first-degree murder charges. His lawyer explains why, as the prosecution confirms publicly for the first time that genetic genealogy was used to identify Kohberger as a suspect and that the DNA in the case is a statistical match. I'm Angenette Levy. Thanks for joining us here on Law and Crime. Bryan Kohberger faces burglary and first-degree murder charges for the deaths of Maddie Mogen, Kaylee Gonsalves, Xana Kernodle, and Ethan Chapin last November in an off-campus home in Moscow, Idaho. We've known since Kohberger was charged last year that prosecutors claim DNA found on a knife sheath on Maddie Mogen's bed was 99% likely to have come from a child of Kohberger's father. But prosecutors say further DNA testing has revealed the DNA found on the knife sheath is a statistical match to DNA collected from a cheek swab of Bryan Kohberger.
Basically, that's just fancy terminology for they got a DNA hit. And with DNA, it's not just one test, boom, they got it. There's always a confirmatory test, a second confirmatory test that gets done. I think it's more of a procedural thing.
James Bogan is a defense attorney who's followed the Idaho 4 case. The revelation about the DNA being a statistical match came in a prosecution motion asking the court for a protective order on the investigative genetic genealogy techniques used by the FBI in this case. The motion is the first time the prosecution has acknowledged publicly and on the record that investigative genetic genealogy was used to find a suspect using DNA found on the K-bar knife sheath, which prosecutors now say was found partially underneath the body of Maddie Mogen and a comforter. James, what do you make of the prosecution seeking a protective order for this investigative genetic genealogy material?
The state says in their opening paragraph they're seeking to protect the names and personal information of, they're saying, hundreds of innocent relatives on the family tree, and the names of the publicly available genetic genealogy services used, and certain other information that's described in the motion. It's quite a lengthy motion. Now, I could see wanting to keep innocent parties out of public record for a criminal case, but obviously, what you're always concerned about as a defense attorney is you want to be able to look at everything that could be relevant to the evidence in the case.
Another new wrinkle in the case.
Your Honor, we'd ask the court to set this trial at the very outside of the speedy trial, right? We're not prepared to do anything but ask the court to do that today.
The defense is asking for a speedy trial set for October of this year, despite receiving mountains of evidence from the state, with much more to come. Following that request for a speedy trial, which is Kohberger's right, his attorneys now want to stay or delay the proceedings because they can't reach an agreement with prosecutors on what material they will be given from the grand jury proceedings. Grand jury proceedings are secret, with prosecutors presenting evidence to obtain an indictment against a defendant. Prosecutors used a grand jury in Kohberger's case. The defense asked for a speedy trial in this case. It's set for October 2nd. Now they're asking to stay the proceedings, saying, we can't get the state to agree to give us all the grand jury materials that we want. So the state is now saying they oppose the motion for a stay. What are your thoughts on that?
That's pretty interesting. Well, the state, I'd like to see how prepared they are, but usually when the defense wants to move for a speedy trial, they're trying to pressure the prosecution, but it can be a double-edged sword because it can leave you with less time to prepare, and there's that chance of being found ineffective, but ineffective assistance of counsel. But the other thing too is generally you're not entitled to stuff from evidence presented at grand jury. You're entitled to stuff that falls under Criminal Rule 16, which is evidence that would be presented at trial, and any exculpatory evidence. But things like grand jury testimony, we're typically not entitled to that unless what happens is it comes up at trial where you ask the judge to do an in-camera review of the prosecuting witnesses' testimony to see if there's any significant differences. And if they are, then we're entitled to that. So we can use that for cross-examination. I've had that happen before.
Much was made about Bryan Kohberger standing silent when he was asked to enter a plea to the murder charges. His lawyers say in a new filing that they did that because they may want to contest the indictment. They believe the grand jury process may have been flawed and want to determine how those grand jurors were selected. It should be noted that the bar to obtain a grand jury indictment is very low. Kohberger will be back in court next week as his lawyers argue their motion to have grand jury materials released to them. For Law and Crime, I'm Angenette Levy.